Thank you so much for joining us. And if you are watching this video, you're interested in estate planning. And we have a whole series planned. So we started our previous video, which we will link here for you. Just in general, how do you get started with the conversation? How do you start with the whole process? And we found out it actually really doesn't take a whole lot to get going with this, and the conversations might not be quite as hard as you imagine they should be. We have Mark Kollasch from the Access Law Group join us. He is an estate planning attorney, and he has so far given us some great advice on how to maneuver and navigate this process. Today we'll talk about generation, well, I call it Generation 1, but it's actually Generation Z, or the Millennials. So the difference is, and I took a couple notes, so I'm gonna just kind of check in here. So we're looking, Generation Z is late 90s to the early 2010s. It's hard to believe that they're all grown up already. And then of course we have the Millennials, who are now older, and Millennials range from the mid 80s to the mid 90s, roughly, maybe early 80s. And Mark, which generation do you belong to?
I guess I just realized that technically I am a millennial, which I don't know if I take pride in that or if I'm ashamed in that, but either way, that's where I'm at.
That's where you are. So I kind of just figure 18 through 30-year-olds. That would be kind of the age that we are speaking to today. And when it comes to estate planning, I know I did not think about that when I was that age.
You know, and it's funny because that age can honestly be one of the biggest times to get things going and make sure you've addressed some of the biggest issues. We'll talk more about some of those specific goals and issues that can come up in this age range, but a very big one, even if it feels like we don't have a lot of assets accumulated, we might be dealing with young parents. Maybe people in this age group have very young children. One of the things that we're always going to want to address is guardianship. So talk more about that, but really this is the age group where knowing what you want to do and starting the process, getting a baseline set is going to be very important, kind of an educational room.
Yeah. So I think it's especially hard. So if you have kids, I don't think, or if you have young kids, it totally makes sense to make sure that they're taken care of with the guardianship that you were speaking of. You might not have as many assets at that point, but just taking care of the kids, I think, is important. Another reason why you should have estate planning. So it might not be directly related to your assets, but I always think of estate planning also putting any kind of power of attorneys in place and potential other documents for medical decisions.
Yeah, so actually most estate plans, whenever we're approaching the full plan, the big things are going to be what actually distribute your assets, but there are so many additional documents that are just as important. And you mentioned some of the most important ones right there with powers of attorney. Powers of attorney are usually just going to be while you're still living, so a little bit of a distinction there. And one of the biggest things with powers of attorney is designating who does make decisions. Typically, it's going to be split between medical decisions and also others like financial, just general asset making decisions, those types of things. So those are the usual two types of powers of attorney, but both very important. One of the biggest reasons we need these is because if we don't have them, even if you have a close family member, even a spouse who you think can just step in and make these decisions, legally, they're not allowed to step in and make those decisions without being appointed as a power of attorney. If we don't have those and say I'm incapacitated, can't make my own medical or financial decisions, and no one has been appointed, then we're going to have to go to a court, petition them to appoint someone. And even if we have someone who's close, a lot of times courts want a professional to be appointed to make sure the correct decision is being made. So that's additional time, that's additional cost, and just dealing with the court process we can completely avoid with the power of attorney. So these are very important to have no matter what age you are, very important to have someone designated, and we always encourage a few backups as well to make sure we're not in a situation where a decision is waiting on somebody else.
Yeah, and so what I'm hearing you say is, so there's the asset part, which might or might not apply. There is the legal guardianship for any dependents that you might have. And then there is your personal, let's call it protection or directives. Who should, make the decisions for you. So those are the three parts, and one might weigh heavier than the other. So if you don't have assets, don't have any kind of dependence, obviously the only thing that's left is just a personal directive, getting your own personal things in order. I think the worst thing that can happen is that you have a catastrophe happening, and whoever is taking on that role now is not allowed to make a decision. And when this happens, it's just not a good place to be. So putting that into place, I think, is super important. If you had to make a decision in terms of sequence, what would your recommendation be?
It can depend on the situation, but
hard to choose.
Yeah, my baseline for a lot of situations is it's better to have everything set and not need all of it than to have only part of it set and suddenly be in a situation where you're missing something. So when we approach an estate plan, even if, say you don't have kids of your own, but someday you're planning to have children, we can still address those things in the document. We don't necessarily put names in there, but we'll put any future born children. Here's how we're establishing guardianship. Same thing for different assets. A lot of people in this age range might be just starting out the home buying process, maybe even inheriting some property from grandparents or parents. So it might not necessarily be a situation where, yes, I have property, but it might be something where I'm expecting to accumulate assets. So even then, we don't necessarily have to name any specific assets in a document, but we can still provide for how those are going to be distributed. So that's my preference, is let's get things set. And then if we need to make adjustments in the future, it's much easier than not having what we need present. But absolutely, powers of attorney are going to be a priority for anyone, no matter if you have lots of assets or barely anything. We also do include an advanced directive, or what's sometimes referred to as a living will. And this is just dealing with end-of-life decision-making related to life support. So again, kind of a specific situation, but one of those things we don't want to leave up to somebody else and don't want to put the burden on someone else to make those decisions.
What I would like to know for the person that is watching, especially if you fall into this age range, have you thought of estate planning, the directives to put in place? Have you given any of this thought? And if so, I'm just curious what you've done. Leave a comment below, and I can't wait to see what you guys are saying. You being a millennial, can you relate to the phrase, well, I'm just going to download it off the internet?
Absolutely. I think that unfortunately we're kind of in that YouTube generation where if I have a problem, I go look, there's probably a video that I can learn how to do it myself. And I've done that many times with car repairs, that sort of thing. The problem is when I go and do that on my vehicle, and then 5 years down the road, I realize I've shortened its life by 20 more years or something like that, I can start to kind of throw a wrench into my own plans by doing something myself. And that's true in this situation as well. I think that there are certain situations where having something that's very simple, very straightforward might be all that we need. But really, most of the time when we get clients who show us their own hand-drawn up wills or things that they downloaded a template from the internet. Most of the time when we're looking at those, they're not accomplishing the goals that the client wants. They are maybe doing a baseline bare minimum, but they're potentially exposing things to the probate process, to have some creditor issues in the future. So even though, having something is better than having nothing, we don't want there to be a misconception that going in and downloading something on the internet is going to be just as good as setting up an entire estate plan. And I do think too that that's one of the misconceptions that my generation and a younger generation has, is this isn't necessarily something I want to invest time and money into. However, investing time and money into it now means that later on we're saving a lot more money through avoiding probate, avoiding huge costs with that whole process.
Okay, so, well, but I as a Gen Z generation person, I don't have money to do this. What would you recommend? Or not a lot of money.
Sure. Well, and the good thing is most attorneys here in Colorado, especially here at Access Law Group, we're willing to work with people on, let's get something set up so that you can have something ready to go if anything happens. Or maybe we'll approach it kind of piece by piece. If you really need powers of attorney, but you don't want to invest in a whole plan right now or can't due to lack of funds or something like that, we'll work with our clients to make sure they get what they need in the timing that they need. There's a lot of ways that we can be flexible, and we want to make sure that people can get what they need, even if it's going to take some time to get everything perfectly in place.
Okay. So do you have any experience in regards to choosing parents as decision makers in the process, either in the paperwork or they come with, your client to the appointment? What's your experience with that?
Yeah, it's more common than a lot of people would think, just because a lot of times when people in this generation are approaching us to ask questions about estate planning, a lot of times it's because their parents just went through the same process and they learned everything and said, my kids need this too. They're getting up in the age where they're going to need these things set up. So it's not uncommon for parents to maybe push their kids to do this, or for the kids to want to have their parents present to talk through some of these things. And that's totally fine. We want to make sure that all of the required opinions and input into this situation are there so that people can make the best choices. It's also very important that each individual is making his or her own choice. So okay. we're very adamant that at the end of the day, everybody has 100 different influences going into their decision, but as long as it's your decision that's being made, that's what is most important. But I think the other side of that question is some people, when they're putting someone in charge of their estate after they pass, or as a power of attorney, something like that, sometimes people will want to put a close family member, and that's a great idea because they'll have close personal knowledge of your situation. However, we do discourage people from putting their parents in those roles because it's very difficult for a parent to make extreme medical decisions, to deal with a child who's incapacitated. The other big side of that, and this is one that's not as easy to talk about, but most of the time, a child's parents are going to pass before the child does. And so if we can set it up so that we're not going to have to come in and change everything, then it's going to be better to have, maybe first choice is someone at your age or a bit younger, maybe have parents as a backup or a contingent agent in those situations.
Okay. Yeah. Well, yeah. Good points. So, okay, I have made up my mind. I want to get my estate in order, or at least get started. What's the first thing I need to do?
So the biggest first step is kind of a summary of some of the things we mentioned in the last video, but making sure you have an idea of what your estate looks like. What are the significant assets that you're going to want to address? The next biggest step is kind of taking the leap and diving in by scheduling some kind of initial consultation. We always encourage people to do some research, get an idea of what you want, but there really isn't any substitute for sitting in a room and talking these things over with someone who's drafting it. There's a lot of great information on the internet, and there's also a lot of misinformation on the internet. So bring all of that, because we can sift through everything and make sure that your goals are being accomplished.
And in the end, I mean, even if when we're just talking in general about estate planning, because every situation is different. And that's why, and I like the fact that you guys actually offer 45 minutes, just free consultation to maybe just see what's needed, what needs to be done. I think that's extremely helpful, and maybe helps to just take that next step then to assemble paperwork and names and what have you.
Yeah, that first step can be one of the most difficult ones, just because if you don't know where to start, it's hard to start. So that's why we want to make sure if you can just get that initial consultation scheduled. We're not going to charge you. We just want to make sure that we can get that ball rolling.
Okay, so I don't want to get into the weeds of things, but I think guardianship for young children is generally a pretty big subject. Can you just briefly touch on how you would just navigate that specific situation to make sure a minor, not a guardian, but a minor is taken care of?
Absolutely. Guardianship is actually always going to be addressed in a will. So whether you're just creating a will or you're creating a trust, no matter what, we'll have a will that addresses guardianship. One of the biggest things that's part of guardianship is any parent, whether it's adopted parent or a natural parent, that person has priority for guardianship. So the good thing is, in most situations, if there is another parent who's living, we've already got one person as a backup guardian. Not every situation is the same though, so we want to make sure if that's not the case, we have the next person designated. But we do the same thing in all our documents. We include some backups, however many backups people want to include, but we always encourage having at least 2 people listed. Probably best to have at least 3 people listed, but if you want to put a few more in there, it's never going to be a bad thing to have some fail safes in there.
Okay, and just to get this right, with having any kind of designations to guardianship in the will, because it's not connected to assets, it doesn't have to go to the court. Does it still have to go through court?
Guardianship is one thing that the law requires to go through a court process.
Makes sense.
Yeah, we have put a high priority on making sure that process is set and done in the correct way. And the reason we want to make sure it is addressed through the will is because that will help avoid any kind of foster care or a child going into the system and not being able to be with family, be with somebody that the individual wants that person to take care of their child. So we absolutely do that in the will so that when it gets to a court, it's an easy, streamlined process. One thing we include with our plans too, when people are designated guardians, is basic instructions for how they would want the guardian to raise the child. Maybe, certain types of visitation, certain types of schooling, religion, that sort of thing. We want to make sure that the parent can write those things out so the guardian, again, has a frame of reference and knows those personal details.
That's a great point. And on that note, I think we've touched on everything in this regard for a younger generation. So thank you so much. We will continue and in our series and have 2 other videos coming up that touch on, Gen Xers, and also on our favorite boomers. That is the last video in the series. And of course, we connect everything below. So don't miss that. Thank you so much, Mark.
Thank you.
For this advice and for your tips in regards to estate planning. And check out our next video for the Gen Xers.